Evening, everyone. Just the usual back office stuff whilst I'm just forgotten to line up even this time. Just bear with me a sec. We were talking about it's always sunny in Philadelphia too much. Bear with me. So, usual stuff. This isn't legal advice. It's us trying to do our best here to be helpful. And actually, certainly one of the questions when we don't have the knowledge probably to actually do justice to it, we'll try and be helpful as best we can. But yeah, in terms of kind of actually knowing the ins and outs, I'm actually not quite sure what the answer is, and I don't think anyone else will do either at this point. I'll explain a bit more in that in a minute. Just let me get the blurb up onto the live chat. So yeah, there we go. Yeah, cool. Welcome everyone. Hope you guys are doing all right and having a reasonable time of it. Three questions have come in through the week, all of which are anonymized, so we'll get into them in a moment. Before we get onto that, just a bit of notices and stuff. So I've just been working today setting out the next 3 months or 4 months worth of training for HBP. So there's the usual introduction to homelessness law course. There's 3 dates, I think, between now and Christmas. I'm going to take a gamble and do two of the priority need ones, and I'm going to do a data protection one as well. So haven't announced that one yet or published it, but just keep an eye out for it. The priority need ones are on the 19th of September. It's an introductory price of 45 quid because it's the first time I'm delivering it, so it's going to be a bit rough around the edges, but it will still be a sound course. So yeah, that's that. Other bits and pieces. Keep an eye out for the dash form. So the domestic abuse stalking and harassment form. Couple of stories that came out in the news this week. So what's her name? Jess Phillips, who I actually think is pretty decent out of all of them. She is basically, it seems like she's basically looking to do something differently with the dash form because basically they did a load of research on it and they realised that most, if not all, most of the people who were murdered uh, through domestic abuse were actually picked up only as like medium risk on the dash. So it's clearly not doing its job well in terms of identifying who's actually at risk. So I think we're going to see more about that at some point. And Lambeth case today. No, not Lambeth, Lewisham, sorry. Or an announcement from the local government, the social care ombudsman, worth just kind of dipping into slightly for a moment, because first of all, this is a thing about the being advised to wait until the bailiffs come, and which is what happened here. And it was particularly unfortunate because the kid was unwell. I haven't even read the full report yet, but there's a few bits that stood out to me. So first thing to say is they got something like 9 grand, £9,500 compensation. A lot of that was basically paying back what they'd had to pay out because of the council's cock up. So it's not that they got they've got 9.5 grand, but they did get £1,000 for the distress, which is actually quite a high payment from the LGO recommendation. But what I thought was interesting was, where's it gone? It might be, it might be dug away in the. It is as well. Hold on. So it's basically somewhere it says what the actions that Lewisham need to do, and basically it said that. Yeah, here we go. So if we just read from here, it's not doing. Yeah, there we go. It's from here. So the council recently completed its action plan to address failings in homes and services following previous ombudsman report. Blah 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 blah. So they have to provide training and guidance to relevant staff about this whole issue about at what point do you become homeless, and talking about how officers need to look at that. There was here. This is an interest. No, where is it? There's a bit. Oh man, I had it a minute ago. There's a bit which basically says, here we go. Yeah, here. So that Lewisham have to go through all of their cases and identify all open cases where an applicant who may be in priority need has remained beyond the expiry of the Section 21 notice. So this is kind of exactly what we've been talking about multiple times on the channel because it's such a common issue. But but in most cases, you should be dealt with as being homeless the day after the Section 21 expires, if that's the right, or the same day or whichever it is. So the ombudsman's kind of giving guidance to Lewisham as to what to do, and therefore kind of this is helpful for any council that's kind of getting up to this sort of practice, which a lot of councils are. And then for those applicants, it decides are homeless and might be in priority need, provide interim accommodation. Now, interestingly, I'd say this is actually the wrong threshold. The LGO have actually got this wrong because the threshold of Section 108 interim accommodation is where you might be homeless and you might be in priority need rather than you are homeless. So the council shouldn't have to be satisfied that the family is homeless before they provide or offer interim accommodation, but it's still welcome. It's still, what the LGO is saying here is better than what Lewisham and many councils are doing anyway. And so yeah, just it's just kind of telling councils that effectively, or telling council officers that in every case they've got where the Section 21's expired, there needs to be some kind of written, recorded consideration of whether or not it's reasonable to continue to occupy at that point, which needs to be reviewed as every stage of the possession process, which is what says there. So yeah, interesting case. As I say, I think although Section 21 notes evictions are going with this new legislation that's coming in next year, it looks like, to be honest. The fact of the matter is you'll still be able to claim compensation if your council told you to wait until the bailiff comes for another 12 months after that change. So it's still actually very relevant. It might be as more as relevant as ever, really. So yeah, what else? I think that's all the news. Well, that's the other bits and pieces that we want to talk about before we get into it. Anything from you guys at all? Any sort of stuff you noticed in the news at all? There's another interesting. I saw it on the BBC. There's a charity in Oxford. I forgot what it's called now. I'll find it. It's like Change something or other. But they've been kind of part of this pilot of kind of giving people money when they're homeless and sort of seeing what they spend it on. And the research says they spend it on good stuff, like furniture and carpets and stuff like that, and just how much of a positive thing it is. And that's what we saw when we worked at Just Us. When I worked at Just Us for me, we're doing that for 10 years. When someone moves into a property, giving them £500 to go and spend on whatever they want to get, usually spend it on white goods and furniture and stuff like that. So yeah, it's good to see that kind of thing being put out there a little bit. And just it was nice to see an article about homelessness, which wasn't the usual shit. So yeah. Cool. Right. Let's get into it. So yeah, sorry, I just didn't actually wait for you guys to answer. You guys got anything news at all, or should we get into it? Yeah. What you
No,
got, Sharon?
just to add to the change thing, because I was reading that just before joining. What I also really liked about the article, and I just think it's important to say because I will often slate articles by various news people, but they had like a little disclaimer at the bottom from the organisation, basically saying like we understand that this isn't isn't going to sort of affect the root cause of homelessness, and there's wider issues and whatnot. And I just thought that was quite refreshing to see in an article that it was a
Yeah.
bit more like whole picture rather than sort of top lines. And that's
Yeah.
it. Sorry, we can get on with it
No,
now.
that's cool. No, that's all good. Yes, it's a good point. Um, yeah, cool. Let me get me.
I was just going to also say there was another article, I should have sent it across, which is how much of abuse is given to housing officers
Yeah.
and how they're under threat to do their job. I think looking at the other side, I mean, when you've got to, we often say the power imbalance is there, but where there's consideration for what the housing officers are doing and not what they have to deal with, but what the situations they're in and how to come to that balance. I think that's an important factor to look at the overall picture as well.
So send it across, Karis. I think I'll be interested to read that. I mean, my sort of knee-jerk response is, when I worked at Bedford Night Shelter, like a lot of residents were very unpleasant to us a lot of the time, and I look back and say, well, because we did a dreadful service, and the institution itself was terrible. And I can understand like why 90% of their complaints were completely legit. And kind of, I'm not saying it's okay to go and be verbally abusive or physically abusive to someone, but I can understand the anger in that situation. But yeah, I'd be interested to talk about that more because I think I'm very critical of housing officers a lot of the time, and one of the things that frustrates me most is that a lot of the people I speak to, a lot of the officers I speak to, don't seem to be able to see that kind of the bigger picture of what they're doing when they're depriving someone of housing, like unlawfully. You can understand why someone's going to get raging about that. So yeah.
And when you're in that position, like what constitutes as abuse? If someone's quite often you'll be like, you would have just said something and they'll be like, don't be rude. So you're stuck in that phase of instantly the minute or you've asked a question or questioned something, they're like, you're being abusive now. I will put down the phone. I will ask you to leave. So it's that kind of power imbalance, isn't it?
Yeah, yeah. I just this is any housing officers watching this could be absolutely enraged
Crazy.
by what I'm about to say. But like I'm just sometimes the ability for housing officers to feel like they're the victim in this, and I'm like, God, you've just screwed this family over for years. You are not the victim here. You had other choices. You could have you could have raised a grievance, you could have whistleblown, you could have refused to follow orders to kind of gatekeep or whatever, but you didn't. But I appreciate it. That's just my side of it. So yeah, as I say, interesting one to return to at some point. But yeah, sorry if you just sent it.
I put it in
Yeah,
the chat, so I was like,
yeah, got it. Let me hold on a sec. I'm going to stick it into the live stream for anyone listening as well. I think, am I? Is it going to let me do it? And try it.
I mean, and what their training is when it constitutes to dealing with de-escalating a situation would be, or how they're addressing people in that kind of a role, and
yeah,
actually understanding.
so I think de-escalation goes some way, but again, like if you basically deny someone housing, then you can de-escalate as much as you want. They're
Yeah.
still going to be angry. But yeah, maybe I mean that I've just put it in the live stream chat, so anyone wants to have a look at it, have a look, and I'll have a look at that properly at some point and maybe be a bit more balanced about it. So yeah, cool. Thanks, Karis. So yeah, let's get into it. Question one, that's coming through. But just to say as well, for those asking questions, if you ask a question in the week, you'll get a quicker response in the live stream because we ask them first if they're anonymized, and it also means you're not affected by the character limit on the live stream chat. So just, I mean, I'll say we'll take questions in the live stream, but if you want a quicker answer, just ask it in the week, and you do that just by asking the question on any comment on any video on the channel, and I'll get a notification basically. But anyway, yeah, let's get into it. So first question, and I have not got a clue what the answer is here, but basically I had a question come in from someone who has basically been acting as guarantor for a family member, and their family member has basically decided to stop paying the rent and not tell the guarantor about it. And so the landlord or the agent's now chasing the guarantor saying, you owe us money. And she's like, don't have the money, to be honest. Have you guys got any experience of that kind of guarantor? What happens next? How likely is that the case will go to court? How likely is it that the family member, the guarantor, will have to kind of stump up cash? Will?
Yeah, I have come across this, unfortunately. Well, fortunately, because I can answer the question, but it's an unfortunate situation to be in if you are a guarantor and this happens. Because in the cases I've seen, it did go to court, and the simple answer to the question is, as guarantor, you're sort of putting yourself in the shoes of the tenant, and you are liable for whatever the tenant's liable for in terms of, well, it's subject to the terms of the guarantee, but normally it would say something like, I hereby guarantee that the tenant will pay the rent, and I accept liability for any rent that they don't pay. Now, the other bad thing is that before accepting you as a guarantor, it's likely that any sensible landlord would have done a bit of a credit check to see if you're good for the money. Like if you've got a property somewhere or you've got some assets, and then they know they can get their teeth into them if the tenant defaults. Because one of the problems with tenants not paying and defaulting is that what most landlords will find is that, number one, there's no point in, you can get a possession order and a rent judgment or rent arrears judgment for whatever, but once you've evicted the tenant, you don't know where they are. You could track them down, but if you did, the odds are you'll find they haven't got any money. So the expression lawyers use for that is, you're really just throwing good money after bad, and you'd be better off just writing it off. Whereas if you've got a guarantor, number one, they're probably not going anywhere, and they've got some assets which you could get your teeth into. So it is a very dangerous thing to be a guarantor. But if the person asking the question or the person is about hasn't got any money that the landlord knows about, then the probability is they won't pursue it. But be careful, because that's probably why they accept you as guarantor, because they thought you were someone you could pursue. So I'm sorry if that's really worrying news.
I think they're expecting it to not be good news. I mean, so I don't know much more about the person's situation, the person who asked the question, but I don't know they have assets, but I do know they're in employment. So I wonder if like the kind of guarantorship was agreed because they're in employment. Maybe I don't know. I'll go back and find out and maybe just kind of give them that extra detail. But that's helpful, even though it's depressing. Or a difficult situation to be in. I mean, and let's say they do have assets, and let's say they own property. I don't think they do, but let's say they do. Does the estate agent will they take it to court, and will the judge have any sympathy at all for the guarantor? In terms of like, I don't know, trying to
Um,
make it
well,
as
yeah, I mean, I can't say whether they will or not, but if the guarantor has got a house and the estate agent knows that, then that starts to get into the territory of it's becoming worth it to take enforcement action. Because what you would do is that they would get a charging order over the house, and then that's the equivalent of getting a mortgage. And then if you don't pay the money that's secured, they can go for an order for sale and get you to get the court to order the sale of the house and the payment out of the money from that. So it's scary if you own a property, and
yeah,
if the estate agent or the landlord or whatever thinks that they pick up the scent of money, they might well do that because it's only a question of filling in half a dozen forms
yeah.
and paying his court
Well,
fee.
as I say, that's helpful, although it's depressing. So yeah, but thanks, Will. As I say, I'll kind of go back to the person and kind of try and
Yes.
give it that bit of nuance. But yeah. Um, so that's question one from the week. Next question here. The next two questions are actually they're big questions. I don't think we're going to be able to do them justice, but we'll have a go. So guidance, and I'm not exactly sure what the question is here. Guidance needed on challenging suitability of housing with a local authority. This is following a medical outcome past 21 days, struggling to get a legal aid solicitor. So it doesn't. I'm not quite sure here whether the person has moved into the property and has failed to challenge it successfully, or whether
Mm.
they refused it. And I think that's probably the first thing we need to establish is, and this is what, it's difficult to go, you can't go back in time to fix it. But potentially, if you've rejected the property and the 21 days has passed and you haven't put a Section 202 review request in, and I'm assuming that's the stage we're at here. I don't know for sure because there's other details that we don't know here. But then I'm not quite sure what your next step is. It's pretty bleak. Other than potentially asking for an out of time review. It says here in terms of like medical needs or whatever, there might be some stuff going on which might explain the delay. Um, so I think, yeah, that's kind of, if I'm reading that right, that this is at the Section 202 stage and you haven't put a review request in within the 21 days and you've refused the property, then I think it's a very serious situation you're now in. Um, yeah, how are you guys reading that question, or have you? Because this is all I've got for this one. I don't have anything else for it. But in terms of what else might be useful to say at this point,
No,
um,
I'm reading it sort of the same way you are.
I mean, I think if they did accept the property and they didn't challenge the suitability, then in one sense, if suitability is like an ongoing thing. In one sense, I'm being slightly clumsy here. There's two very closely related terms within housing law. One is suitability, and one is whether it's reasonable to continue to occupy the property. And they're actually not quite the same thing, although they look very similar. But if you have accepted a property which you don't think suitable and you haven't challenged it within the 21-day limit, you could still make the argument, which it'd probably be exactly the same argument, to be honest, to say that yes, I have a tenancy, yes, I accepted it, but that's actually not reasonable to continue to occupy. Therefore, I'm legally homeless, and you effectively make a homeless application again from scratch. That would be a possibility again if this person has actually moved into it, and you basically lay out the argument there. Let's say the medical issue was if something really clear cut, like there was 3 flights of stairs and this person uses a wheelchair and there's no lift, then it's a pretty strong argument. It wouldn't really matter that you missed the 21-day limit. But I think if it's more nuanced than that, because those two concepts aren't exactly the same, then I'm not quite sure whether you'd always have the ability to come back from it by making a fresh homeless application. So yeah, I don't know if that person happens to be watching the live stream, but if they are, and they can shed some more light on it, that might be very helpful. Um, so yeah, we say every time suitability comes up, we need to do a proper in-depth video about suitability at some point. But Will, I know, is up to his eyeballs, and I will soon be. So yeah, not quite sure when that will happen.
Get there one day.
Yeah, yeah. And then thirdly, again, a really important question, and again, I don't think is actually something we definitely know the answer to, but I can shed maybe a bit more light on than it has when it's come up before. This week, there's been a number of questions similar to this, either come up for the Facebook group or on the channel. And so this question here involves someone's PIP, as in I assume an adult here, but there's also a question that came up when the child was getting DLA. And I think the situation would still be the same actually for both. But this this idea of, can the council look at your PIP and say, right, you can afford your rent because you're getting X £100 a month from your PIP. And my best understanding of this is, but I'm still only about 70% sure of it, is that councils can look at, so let's say you're getting £100 a week from PIP, and that PIP is for mobility issues, so you're getting taxis and stuff because maybe got a mobility issue, but let's say on average you're only spending £50 a week on taxis, and there's nothing else you're using in terms of mobility stuff, then the council will be able to look at the other £50, the £50 you're not spending on taxis, as part of your kind of your disposable income, so to speak. So but the case law on it is very confusing, because there was this big case back in 2018 called Samuels v Birmingham, which was a good case. There was this other case which I've seen reference to, and I'm actually going to share the screen and just kind of show you what I'm looking at. So it's called Compton v Bexley. I cannot find a transcript for it. The only references I can find to it are written by the Cornerstone barrister who presumably acted in the case. And I might be wrong in saying this, so if I am wrong in saying it, I apologise, and I'll happily correct myself in some future live stream. But I seem to remember that when Cornerstones reported on the case earlier this year, I think it was the Beach case v Devon somewhere, that the kind of the account that the Cornerstone gave about it wasn't actually terribly accurate. And I seem to remember Giles Peaker, who is kind of like a very famous lawyer, very active on socials and LinkedIn, and used to be on Twitter. He was pretty critical about the way they span it. So that makes me slightly, there's room within the way this has been written here. So I don't know if what you can see. I'm trying to get rid of this advert. Can't, but yeah, then I'll put the link into the live chat as well, actually, just so you can get that in a minute. But yeah, it kind of says so. So basically, this case happened at roughly the same time as Samuels, and so Mr. Compton argued that disability benefits ought to be treated as if they were ring fenced and therefore excluded from affordability assessment. But the appeal was dismissed, and Lord Justice, if that's what that means, Asplin, said that the issue of whether disability benefits could be taken into account is answered by the decision in Samuels. Now, I haven't read the Samuels case in a year or so, but I seem to remember the Samuels case being a very good case for homeless people, because basically what it said was, yes, a council could look at, how much you're getting in for your PIP, but the starting point would be for the council to assume that award from DWP is the right amount, and in one sense, they're not taking any further than that. So the fact you might not be spending it all on your disability seemed, in Samuels at least, to be, that's not actually relevant for the housing officer's consideration. However, there was these two other cases which happened afterwards called Patel and Bapti, which I think does then enable councils to take into account. So that's kind of a long way to get around to this idea that I think councils can legitimately look at PIP if you're not spending it on your disability. Hold on. Bear me a sec. But I wouldn't swear to it. So yeah, I don't know if you guys know more than me. I know it says on the DWP website that this is effectively ring fence, but the DWP website doesn't trump case law when it comes to housing law. So, Shannon?
Yeah, so I know it doesn't trump case law, but I've had good luck in terms of I declare my PIP, but I won't give a figure, which is also really silly because I tell them what my PIP's for, so it's a quick Google and they can work out the money. But I say that it's used for disability, and one of the reasons, and I think it's really helpful if you're in this situation to explain it to a housing officer, particularly like, so there's been a massive spate of reassessments, and PIP sort of being your PIP being reassessed, and particularly when people have fluctuating conditions, and therefore the money is kind of fluctuating as well. And so if you highlight that point and explain that, actually this is money that could go away, sort of not quite any moment, but particularly, if you've got an award that is being reassessed every 12 months, that's actually being reassessed every 6 months because they're doing it earlier to get rid of the backlog. And you explain about fluctuating conditions and what you're spending it on and everything else. I think there is the scope to have a sensible conversation as to why you don't want it included, particularly if you've got, say, like some form of anxiety or worries, and you've got a history of homelessness, and you're really worried about losing your home in the future due to unaffordability. I think explaining that and saying, like, look, this is almost, and I know lots of people don't like this word, but it's almost a trigger, like to be worried about the financial aspect when I'm moving. And I'd rather have that almost as a cushion because it is for my disability. And then I'm not worrying that if I move in somewhere and in 6 months' time my PIP gets taken away, that I'm then going to be end up homeless, because that's not the aim of PIP and that's not the aim of the housing officers. And I think once you sort of have that logical, very like non-emotive almost conversation, lots of housing officers or people would be more understanding, if that helps or makes sense at all.
Yeah, no,
Not to counteract what you've just said, like
no. So I think if you have, I mean, yeah, we. I don't get to see the good housing officers generally because people have got no reason to kind of have an issue with it. But so there are good, yeah, plenty of good housing officers out there who I think you can have those kind of reasoned discussions with, and basically just say exactly what Shannon just said in terms of kind of how it should be dealt with in the real world. It's not some like sort of, kind of abstract formula they have to apply. It's about actually how does this person actually deal with their finances, and the evidence of that assessment needs to be in the actual notes. So there needs to be evidence of a real assessment being carried out about the person's real situation, um, given their very kind of varying things that are going on for them. So yeah, I think this is. I mean, I'm going to try and track down the full transcript of that Compton case, although I don't think it actually exists. I was certainly slightly dubious of the housing officer who declared that there was case law saying it definitely was okay, because I don't think that's what the Samuels case does, and I don't think that's what that law report says about it either. Actually, I think they're just saying that yes, the Samuels case said it was kind of it's part of the consideration, but Samuels then went on to say, but it's they if DWP give you 100 quid, it's because you need 100 quid. So that's kind of how their take on it was. I still can't even understand what the Baptiste case is even trying to say, which probably means that if you have a situation like this, it seems to be something that would probably end up in court going quite far because the lack of clarity at the moment. The other thing to say as well, just if you really want to get your head around this, is that shortly after the Samuels case, which was a Supreme Court case, the wording of the Homelessness Code of Guidance was reworded because the HRA came out the same year. And that just basically meant that whereas Samuels was relying on the old wording, the new wording kind of brought in this new ambiguity around what housing officers can and can't do. So yeah, I don't know if Will, have you got anything to say about this one?
No, I mean, I was just getting to a bit of research on it, and I was about to read the paragraph that might answer it. But my understanding of Samuel's was, apart from saying there had to be an objective test, that was the big positive from that case. Because before it was, you could get different ideas of what was affordable from different councils or how much of your benefits you should be expected to spend. But they said there had to be some objective standard. But I'm just looking here. I'm looking at the Garden Court report on Samuels, and it's saying benefit levels are not generally designed to provide a surplus above the subsistence needs of a family. In the absence of any other objective guidance on the issue, those benefit levels should be treated as representing a reasonable level of expenditure. The amount that Ms. Samuels was spending each month fell within that amount, regarded as appropriate by way of welfare benefits, and still didn't leave her sufficient resources to pay the rent in full. In those circumstances, the court found it hard to see on what basis the finding of intentional homelessness could be upheld. So there they were trying to, Samuels there was the authority for the opposite, because the council was saying you're intentionally homeless because you didn't spend your benefits on the rent, I think, and
Yep.
the Court of Appeal said no, um, that the benefits were meant for subsistence.
So check the court because they went to the Supreme Court. So I don't know if the wording would be
Yeah,
different.
that
But
was
yeah,
it was the Supreme Court judgment.
okay, yeah, because that's I mean that's I've always taken that to be very very positive. In this,
So,
yes, so it would mean not it wouldn't be. I think if you're going to go into the detail of Samuels, it kind of talked about, yeah, exactly. You just said in the absence of kind of any sort of contravening evidence, the levels that people get from DWP should be seen as. I mean, the Samuels case didn't involve PIP as far as I can remember, but it involved the benefit cap. That's why she couldn't afford her rent, was because she had like hundreds of pounds removed from her benefits entitlement. But I think that the same thing applies. I mean, if I get time, I might revisit all of them in light of this Compton case
yeah,
and see if
I
that
would
changes
like
it.
to. Could you ping me that Babty case? I've got the other ones in my database, but I haven't got that one. Did you say it was reported anywhere?
Yeah, yeah. So
Oh,
yeah, I've got the transcript and it was on Nearly Legal, which is probably where I got the transcript
if
from.
you send me a link, that'd be great. I can stick it in there because I've got the other ones. If anyone's watching, are on my database. And if you search for the tag affordability, you get four different cases: Patel, Samuels, one called Vivian Ake versus Lewisham.
When
Uh,
was that? What year was that?
three, but that's a Morrison Spout case. And I think it might even be County Court. Yeah, it's Central London County Court, and I'm not sure what the outcome was, but it was to do with affordability, and it may, yeah, God, there's a lot here about working out. Oh God, it was all somebody's expenses. Yeah, I think it was where they showed that I don't think it was directly on this point about benefits, but I think that it showed that the reviewing officer, if you broke down their figures, um, the reviewing officer hadn't worked it out properly. Um, so yeah, it says I conclude there are errors in the reviewing officer's assessment of affordability, um, and that undermined the basis of the decision. So that was about the importance of checking that they've actually, worked it all out.
Yeah.
And there they hadn't. So that's on there.
Okay. Yeah. Cool. Yeah. I'll send it to you. Yeah. No
Thank
problem.
you.
Um. Yeah. Cool. I've just seen I've just looked at the live chat. Hey, you right, Alan? You right, Martin? You right, Tiff? You right, Anton? Nice to have you guys here. Um. So we'll get into the questions from the live stream. As I say, the two questions that came through, yeah, these last two, and sorry, actually, all three were interesting. Someone just basically said about the first one, what would happen if the guarantor, if it had happened fraudulently? So let's say the family member had kind of like, forged the signatures of the guarantor and so on. Presumably, if the guarantor could prove that, it would be, be a problem for the tenant, but not the guarantor.
Well, the simple answer would be if he could prove that then the guarantor wouldn't be the guarantor because they hadn't actually agreed to become guarantor. Somebody had just falsely claimed that they were the guarantor.
Yeah. Okay. Um, right, there might be a little bit of a multi-part here. Let me just put this together, see if it is. Um, cool. Is that the last bit? Hold on. I think that's the last bit. So let's put this together. So if a client had been left homeless in a student hall for say 250 days, not having been offered interim or temporary accommodation, being told to simply wait for the bailiffs, is this lawful? Disability adapted property needs. Feel the client has just been left. Expiry of notice to quit was autumn last year. Council claiming no need to act as university refused to take clients to court until last possible moment, as they were doing building work. So I have no experience at all about student accommodation and whether it's different from other types of accommodation. Going back to that Lewisham case that I shared at the beginning, one of the words that the LGO used to describe Lewisham was this idea of brinksmanship, as in they would basically wait until things came to the brink before they would actually act. And actually, what that meant was that harm came to in that case the family. So, um, so I don't know. I don't, as I said, I don't know if the eviction process for a student accommodation is different from a standard AST. I don't know if you guys know at all.
No, I'm just wondering how you can be homeless in a student hall unless the student hall is unsuitable for you. Um, but I'm sorry if I'm missing something. I mean,
So
it's,
what if they've yeah, I don't know if they've been, yeah, if 350 days would be like, they started uni last September and it's now end of August or something, and basically that was only going to be provided for the year or something like that. Would that be? I don't know.
well, because the thing is, if they let you stay there for 350 days, then they let you stay there. Um, the if it's suitable and or you can't show it's unsuitable, the fact that you may have to leave at some point um, doesn't make you homeless, does it? It's not like if you've had a valid Section 21 notice and you know that bit, but
I mean, if
um,
they don't have anywhere else to go back to, I don't know. That would be where they. I mean, that'd be maybe that person could just because clarify what is the stupid question, but what is the source of the homelessness? Is it being kicked out of the student accommodation, or is it the fact that student accommodation isn't suitable
yeah,
because
yeah.
of disability, the adaptive property? There's just some, yeah, okay. So there's just bit more of it here, I think. So this might make a bit more sense of it. So
Um,
end of contract. Oh, sorry, you're gone, Shannon.
no, go on.
I was going to say, so the person just added, so end of contract, inability to go back to previous address due to domestic issues. So domestic issues, I guess, I'd probably hear that as domestic abuse, but that's not necessarily what it means. It might just be there's been a family breakdown. In one sense, that would be the cause of your homelessness. My first thought is if in that situation, because it's not a normal Section 21 eviction process, the council would treat you as having accommodation which you have a legal right to occupy up until the date that you don't. So presumably the university has got like a time scale written into it which says you must leave by the 31st of August or something. And so you can make a homeless application, and a council should accept the homeless application when they're within 56 days of that date because they should start the prevention duty, but they don't have to step in and provide accommodation until that'd be say that would be how I would guess, but that is a guess from someone who's never seen student accommodation stuff before, so I don't know. Karis, you got anything on this one? Oh, there's a bit more in the chat actually, which makes it. Hold on, makes it. Yeah. This is where we are. By the way, guys, for those who are watching for first time, or whatever, there's like a 45-second delay, which is why we don't always see what you're saying in the chat straight away because we're 45 seconds in the future. So, domestic abuse at previous address, council not even started acting until the possession order, but have been here a year unlawfully. Okay, so sounds like this person's been staying there like almost 2 years. That'd be how I'd read that. Um, still don't know. I guess the council's position is because the university is not actually kicking this person out, they're going to say, well, we're going to hold tight until they do. And so the university is probably thinking they're helping this person out, but they probably actually aren't, because if the person wants to make a homeless application and get the process started, I mean, I hold on a sec though, but surely in that situation, you would have nowhere with a legal right to occupy. I don't know. I don't get it. I don't get how student accommodation works.
I'm also thinking whether you're a licensee maybe, and that they don't actually need to take you to court, which could make it closer to being homeless. But if somebody, it sounds like somebody spoke at a council has spoken to the university and they've said, yeah, we're not going to kick them out. And so if they've said that, then it's more difficult to argue that you're homeless, isn't it?
I mean, I guess that if this person hasn't done this already, the kind of thing to do would be to do a robust homeless application, get it all in writing, and then get the decision from the council which says, yeah, we don't think you're homeless and the reasons for it, because they'd have to give the reasons for it, and that might bring you slightly closer to an understanding of what you can do to challenge it. But yeah, I mean, again, if this person's done that already, this person saying there's no legal right to occupy, in which case they'll be homeless. But the university, as I say, might not be being as helpful as they think they are by letting it roll on. But I think make the homeless applications. There's a video on the channel if you haven't seen it called "The Best Way to Make a Homeless Application," And that just sets out the steps of what it is you want to include in the email to start the homeless application. Because we don't know this, but this might have all happened kind of verbally. Like the person's rung up the council, they said, "Oh, we're not going to do anything," but nothing's in writing yet. So I'd be saying put it in writing. Shannon?
They've just said that despite having full duty since January, which I'm
Okay,
assuming
that's weird. Okay.
means the full homelessness
Yeah.
duty, which means
Yeah.
like none of this makes sense. Because my thing was going to be like, I can imagine, I can foresee one of the issues going down this route is that the council's going to say there's no local connection because you don't get local connection from university. At which point I was going to suggest, like, well, make sure that you're clear that, if you are at risk of abuse in a different area, then you might have no local connection anywhere and what have you. But if they've got the full duty, priority need two. So it's definitely like they're definitely talking
Yeah,
about the
if
main
they, yeah,
duty here.
okay, I think then complain and say, you owe me the full duty. You've not provided suitable accommodation for me, and see where that goes. I mean, complaints, the bad thing about complaints is they're not quick, but in one sense, if this has been rolling on for months and months and months, I don't know. I don't see any, that's just a very weird situation to be in where the council's accepted you are homeless by the fact that they've issued the full duty, but they're now saying, "Oh, we don't need." I mean, that just stinks. Basically, there's I don't see how that would be possible for the council to try and maintain that they don't have a duty to provide temporary accommodation now under Section
Unless is it
193.
is it the fact that there's a disability adapted property needed? And because we've seen that a lot where local authorities are then so unbelievably slow with finding suitable interim or temporary accommodation because it needs to be disability friendly or adapted. And that's the excuse they use. I wonder if that's the barriers to why they've not got temporary accommodation.
I'm going to be honest with you there, Shannon. I was reading the chat while she said that, so I don't know. Just
Is
to say on that,
is
just to say on that. So, guys, when you ask questions, if they're in the first person, I'll remove them. So that's not me being trying to be difficult. That's just me sort of making sure that the questions aren't disclosing personal data and all the rest of it. So that there is a reason for it, and it also changes the way we deal with questions. So you'll get a better answer by anonymizing it. Sorry, Shannon.
Grant, I was basically just saying, is the barrier to this person not having temporary accommodation the fact that it needs to be disability adapted? And the local authority is basically saying, we don't have any disabled adapted temporary accommodation, and therefore we're leaving you where you are instead. I
Yeah,
would query that.
so that would be that if that is the case, then that would be a straightforward complaint because what the council is basically saying is, yeah, we owe you a duty. Yes, it needs to be suitable. Yes, it needs to be adapted. But no, we don't have any accommodation, so we're going to leave you in the university. That would be if that is the case, if that is what we're talking about here, then that's actually a very easy compensation claim, and that's actually quite a lot of money because in effect, I'm trying to think of, I mean, the number of councils have been caught out. In effect, the big Imam v Croydon case was effectively this issue, but there's been other cases as well where the LGSCOs have got involved and they've basically issued large, thousands of pounds worth of compensation. So I think having kind of meandered around there, I hope this is helpful for this person. But I think my renewed suggestion would be to make a formal complaint. And there's a video on the channel called "The Best Way to Make a Complaint" as well, which again seems quite laborious, but it does set out the steps you want to take. But yes, because in one sense, it's kind of a good thing that the main duty's been accepted. That just council's just weirdly not doing what they should be doing, it seems. So yeah, I don't know. Say, hopefully that wasn't too rambly to actually be any use at all. Yeah, cool. So next question. Um, Struth, is that me or is a load just dropped in? Um, so here we go. Question 5. It's a multi-part, just bear with me. think this is the second question. Okay, I think that's just that's a self-contained question there. So, person is waiting for Section 204 appeal at County Court, which is scheduled for the 17th of December. If a solicitor had to change the grounds of an appeal resulting in a new appeal submitted to County Court, can it delay the actual court case? For example, rather than it being in December, could it be January? I don't know, but Will or Karis will do. So I'll leave it to them to answer. Will?
Sorry,
You're
I was
muted.
still looking at. I was trying to answer the question: what is the legal status of a person in a student hall of residence? And can I just tell you, since
Yeah, go for it. Yeah.
I think I'm looking at an article on the Anthony Gold website, which is Giles Peaker's firm, although it wasn't written by him. So if you're in a student hall of residence, you're a licensee, but the view seems to be that you're nevertheless covered by the protection from eviction. Because normally licensee, they go, dear, that's like a hotel or B&B. They can just tell you your booking's ending tomorrow morning. We want you out, and they can call the police and stuff. But they're saying that you are covered by the Protection from Eviction Act. So the landlord, the student hall of residence would have to get a possession order, but they don't have to give any reasons other than we've served the notice and we've ended the license. So sorry, that's that one.
Yeah.
So the
So this
question
one
that
here.
was
So
asked is,
if a solicitor has to change the grounds of an appeal, resulting in a new appeal being submitted to the county court, can it delay the original court case date, which is the 17th of December?
yes, it could. Well, yeah, I mean, it could. Well, hang on. If the no, well, it needn't do, because if you've got a hearing date listed for 17th of December, and even though that is getting closer, it's easy to think, oh, that's months away, but actually it's September to next week. So you want to amend. So what would have happened at the beginning of the case? There would have been directions to say you've got until such and such a date to amend the grounds of appeal after you get the housing file from the council. And then if you then needed to change it after that, you'd just have to apply for new directions. And if you could fit a timetable together to say, okay, we've just amended the grounds of appeal, and as long as all that happens after the grounds of appeal is that the two councils have to the two sides have to submit skeleton arguments. And so if they've still got time to put in skeleton arguments, then that should be fine. So it could delay the case, but it's not inevitable that it would do, if you see what I mean. Whereas if you had a possession case if you tried to amend the grounds the day before the appeal, then yeah, it would. But if it's like best part of, well, so we've still got October, November, 3 months, that would be fine.
Cool. And then next question. Hold on, let me just actually copy and paste the right bit. So this is another two-parter, just bear with me. So person submitted the first stage complaint to the council, received a reply, and then escalated to second stage. Good work. The first stage complaints are very rarely upheld. This person asked the council for compensation and how the council will improve and deal with future housing applications in second stage complaint. If a person wins the court case, can it result in significant compensation due to distress, harm caused, time and trouble? So I'll give you a partial answer to this. You don't need the court case to get compensation. And I'm not sure I've ever seen a case where the outcome of the court case changed what the LGSCO said. I might be wrong. I've never noticed that happening. So in one sense, the LGO will if it's upheld, the LGO will recommend compensation, and there's different elements to the compensation. So that, for example, there might be an element of compensation for the time and trouble taken to make the complaint. That's usually 100 or 200 quid. It's not a lot of money. The distress and harm caused, it would depend on what level it was. I think the upper limit tends to be about £1,000 for that. I think they can go over it, but it's not often that they do. So I don't know. I mean, I'm interested to know how the LGSCO will look at it. Let's say it's a question about suitability of accommodation, for example. The LGO would be looking at did the council follow the right timescale for the process? Is there evidence in the notes of an assessment taking place? Whereas the court would tend to look at, was the assessment right? and the LGO won't look at whether it was right or not. They'll just look at whether the process was followed. So they're kind of two separate sort of tracks, I guess. And I don't know. I just don't remember seeing a situation where the kind of the winning of the case in December, let's say, changed kind of how much compensation the LGSCO recommended now, because they're, as I say, they're kind of actually separate questions, I think. But yeah, I might be wrong about it. I think in one sense it doesn't change your approach, because your approach is going to be the same. Make the best complaint you can. Make sure you include all the relevant information. Try and keep it concise. Use ChatGPT or whatever to help you out if it's easier. Involve counsellors as well is not a bad idea, I'd say. But I think my experience with the LGO is, once you kind of wait around for them to actually start investigating, because they've got a big backlog, they're actually pretty good, and they'll kind of like, they'll you won't lose out because you didn't mention something. They'll kind of like their job is to kind of know what the law is. They don't require you to know what the law is to actually kind of get the case solved or whatever. So I think that's my answer to it. I don't know if you guys have got anything else to say about this one. No, cool. Done that, done that, done that. Tiff, I can't help with DWP stuff, I'm afraid. So I can answer this question here though. Hold on. Do councils have special housing officers for vulnerable tenants, and should they have allocated one to vulnerable tenant, please? So the answer is potentially yes. I mean, every council does everything differently, but often councils will have specialist officers, and I use that term loosely because I'm not convinced that the specialists necessarily get any training really. But so for example, you might have like a specialist domestic abuse worker who is a housing officer, and that can be great. It can also not be great. Often that kind of idea of like, kind of cross-pollinating teams doesn't actually work, because that let's say you had an IDVA based in the housing team, you think that'd be a good thing because the IDVA will go ahead and kind of do some great work. But what tends to happen is they just get ground down by their colleagues who aren't very helpful. That's what I've seen anyway. So so some councils, I'm sure, will have officers who are supposedly there to specialise to help people with particular issues. It might be kind of someone else particularly kind of maybe a group of people who have mental health issues or something like that. And so the council would have someone there to try and catch them in one sense. You see it in rough sleeper teams, you have like a housing options team that deal with the homeless applications, but the rough sleeper team are supposedly there to kind of make sure that they get additional support. So I think the answer is they can be, but it's not mandatory. It's not kind of like, compulsory by law or anything like that. Shannon?
Yeah, just because I'm perhaps being a bit pedantic as well, but obviously this doesn't necessarily talk about someone who's a vulnerable tenant but is homeless. And so just to cover like the other side of things, I guess, if you are in like a housing association property, often housing associations will have sometimes they're called different things. Sometimes they're support workers, sometimes they're like independent living advisors, sometimes they're housing officers, but often housing associations will have workers that will sort of do, I guess, outreach work with vulnerable tenants, whether that's on various things like setting up bills or, like you say, domestic abuse or whatever. So it's worth reaching out if you need that support to your housing association to see if they have something similar, but not always.
Yeah, cool. Thanks, Shannon. Next question, unless I've missed something, is a multi-part, so just bear with me. Sorry, there's a few more parts to it. Hey, what, Cheeseface? Feels like it's been a little while, Cheeseface. If it has, welcome back. Cool. So, friend needs adaptations, but not assessing accommodation that's safe or suitable. You previously told I've got a claim against council. So again, just to say, guys, this isn't the
No
place to.
OT assessing.
Oh no OT assessing. Cool, thanks. Just to say, guys, yeah, this isn't the place to bring kind of, if you've got a personal question, and then if I've kind of had previous contact with you, then email me back or whatever. Got a claim against council. Friend did 2.5 years in a hotel as there was no adapted accommodation. Council not adapted, no support, but support in another town. What if her needs are not being accepted? She has a housing and social care issue. She can't access utilities. A doctor or chemist independently and lost great independence in the manual wheelchair. Social service OT taken 5 weeks to assess if it's suitable and safe. So, okay, forgive me, I'm not quite sure what the question is here. I mean, if a council said, yeah, but I mean, if I have a conversation with someone and I say, "Oh, you sounds like you got a case there," it's on the facts you've given me. So if a councillor said we accept you're in unsuitable accommodation, we haven't got anything that's suitable, that is a de facto, that's not lawful for the council to do that. You know, there's no way around that. So that's kind of, if I kind of give an indication of whether I think the council's broken the law or not, it'd be something based on that kind of thing. It sounds as though the person needs to, I mean, yeah, in reality, it might be that it needs to wait. Yeah, they need to wait until the OT has basically done the assessment, and hope that the OT assessment basically gives very clear indication of why it's not suitable. But if the council's already accepted it's not suitable, then, you know, for a complaint, it shouldn't really matter. The OT might add detail to it. But yeah, so yeah, I'm not sure if there's, as I say, not quite sure if there's a different question held within that or not. But I think that's kind of my initial thoughts on that. Really, is that the person's done the right thing. They've got social care involved. There's assessments taking place. Yes, it's 5 weeks away, but okay. I mean, that might just be the best you're going to get. But it's about kind of, yeah, your argument to the council about suitability is just laying out what the issues are. In this case, it sounds like it's, yeah, someone who has a wheelchair need, and presumably the accommodation is not level access or whatever, and just kind of stating that, and to try and speed things up, I think involving local councillors is not going to be a bad idea. There'll be a councillor who oversees adult social services. There'll be a councillor who oversees the housing department. There'll be a councillor who oversees the ward that this person is in. And so those 3 councillors at least will be useful to involve and speed things up. And basically, you know, even if it's just about case about making a complaint and copying them into it, that's not going to do any harm at this point. But as I say, and I guess gathering your evidence together, if the council said that they accept the accommodation is not suitable, then did they say that in writing or did they say it over the phone? Because if they just said it over the phone, it's difficult to prove. So yeah. So yeah, I don't know. Yeah, I don't know what else to add. So she was told it was furnished and adapted, but it wasn't. So I think hoping that the council said that in an email, then it'd be quite a straightforward complaint. You know, council said on this date that it was going to be furnished and suitable. It wasn't. That's a very simple complaint. You don't have to kind of, yeah, overdo it with that really. But it always gets kind of more difficult if it was just verbal. So yeah, I'm hoping the council kind of laid that stuff out in writing. It makes it much easier to kind of then challenge. If they didn't lay it out in writing, I think it'd be a case of making a complaint anyway and just basically reporting what they said. And yeah, again, the video on the channel, the best way to make a complaint is a good way to do it because it goes through it methodically in terms of kind of trying to get the best outcome. So yeah, and I think in terms of Virgos, my impression is that Virgos are completely snowed under right now. So I don't know that. Yeah, unfortunately, I don't think there's the capacity to try and actually get there. If you go on Will's website, there is the list of other solicitors that take legal aid. So I think just have a little look through there, and just unfortunately, it's just a case of just trying every single one of them, see if they do have capacity. So yeah, I think that's it. Anyone want to add anything to that at all, or kind of see a different question that I've missed? No. If not, it is bang on 8:30. So we will call it a night. I think I've covered all the questions that have been asked. So hopefully there's some useful stuff in there today. Will we round on Monday?
I think probably not actually, because I'm afraid I've got to get up in the middle of the night and do another airport run. So probably not.
Yeah. So in which case, I mean, I might run another one of these little informal live streams on the Tuesday or something, but I'll figure that out. But so keep an eye out for that, guys. If not, we'll be back next Thursday, 7:30 p.m. Yeah, and I hope, yeah, as I say, it's depressing, isn't it? But I'm hoping this stuff is useful for people and they can kind of use it to try and improve their lot. So, yeah, all the best, really. It's it's not a fair game, basically. It's not a fair process, unfortunately. So yeah, but we'll see you next